Welcome to the deep dive. Today we are plunging into one of the most critical battlegrounds in contract law. This tension, really, between what's written down on paper and what was actually said in the room. We're talking about the parole evidence rule, but specifically how it works when you're dealing with sales of goods. The core conflict is this. Contract law, it loves finality. But business, commerce, it thrives on flexibility, sometimes on that handshake. So how much weight does a court give to an outside oral agreement, that essential detail that somehow got left out of the final document? Okay, let's unpack this and see how the Uniform Commercial Code handles it.
Right. And our focus today is going to be pretty narrow, really just on the UCC's take here, Section 2002. This rule, it defines when a final written expression, what lawyers call an integrated writing, can be explained or, and this is important, supplemented by outside evidence. Understanding this rule means understanding a pretty fundamental shift the UCC made away from traditional common law thinking. Our mission is strict, nested, elemental analysis.
That difference is really key, isn't it? Because under common law, the parole evidence rule was, it was a fortress, designed often to stop potentially fishy testimony about oral deals. The paper was king. So before we jump into a specific case, what's the actual black letter law under UCC 2202? Where does it, crack the door open where common law might have slammed it shut?
Okay. The general rule still holds that evidence of prior agreements or agreements made at the same time orally, it's not admissible if it contradicts a writing that the parties meant to be final. That basic principle is still there. But the UCC carves out two major pathways for bringing things in to supplement the writing. First path. The writing can always be explained or supplemented by things like course of performance, course of dealing, or usage of trade. So, the history between the parties, how things are normally done in that industry, that context, it's always admissible. Even if the document looks totally complete, the UCC really values that commercial context.
Okay, so context gets a pass. That makes sense for business realities. What's the second path?
The second one, and this is where it gets a bit more complex, is that the writing can be supplemented by evidence of consistent additional terms. Now, this isn't automatic. It requires a kind of two-part test for that evidence to come in. First, the evidence has to be, consistent with the writing. And second, the court has to decide that the writing wasn't intended to be the complete and exclusive statement of all the terms. So if we break down 2202, we're really testing three things. Is the writing final? Is the outside evidence consistent? And critically, is the writing not the whole story, not complete and exclusive?
That structure, that step-by-step check, that's exactly what we need to model for you listening. And if we take that structure, the classic case, George v. Davoli, really shows how this UCC flexibility plays out. Let's analyze George v. Davoli. First, what are the legally dispositive facts? What actually happened that matters here?
Okay, the setup is pretty straightforward. You have a plaintiff, George. He bought some Indian jewelry from the defendant, Davoli, who was doing business as Triple J Turquoise Jewelry. The deal was on approval for $500. They wrote up a memo about it, and it said George would get a $440 refund if he returned the jewelry acceptably. But here's the kicker. The memo said nothing, absolutely nothing, about when he had to return it by. Davoli, the seller, testified they had an oral agreement made right then, setting the deadline for the following Monday evening. George, however, didn't bring it back until Wednesday, 2 days late, according to that alleged oral agreement.
And what was the core legal issue? What specific question did the court need to answer using UCC 2202?
The precise legal question was, is that oral agreement about the Monday deadline admissible? Can it be used to supplement the written memo, especially since the memo was totally silent on the return time?
What rule of law did the court apply to figure out if that oral deadline could come in? Can you state the full rule and break down its testable parts for us?
Sure. The court zeroed in on UCC 2202B. That's the part that allows evidence of consistent additional terms to supplement a final written expression. Now, assuming the memo was a final expression of what it contained, the rule really sets up a two-part test for admitting this kind of oral term. The term can come in only if two things are true. One, the parole evidence, the oral term, must not be inconsistent with what's actually written. And two, the written memo must not be a complete and exclusive statement of all the terms agreed upon. Both have to be met.
Thank you. Now for the court's elemental analysis. This is where the rubber meets the road. Let's walk through this element by element. How did the court tackle the first element, that requirement that the term must not be inconsistent? This seems like a big hurdle.
It does, but the court performed a kind of mini IRXE just on defining inconsistency. And under the UCC, it's a surprisingly low bar. They relied on an interpretation from another case, Hunt Fuda Indy v. Doliner. And that case set the sub-rule. To be inconsistent, the oral term has to actually contradict or negate something explicitly in the writing. If it just limits or clarifies something, even significantly, but doesn't directly clash with a written term, it's generally considered provable.
Hold on. So the writing said return on approval, which usually implies
Right.
a reasonable time. Isn't setting a super specific deadline like Monday evening contradicting that general idea of reasonable time?
You'd think so under older rules, maybe. But under the Hunt Food standard the court used, it requires an explicit negation, a direct conflict. Since the written memo mentioned nothing about time, it was completely silent. The oral agreement setting a time didn't technically contradict anything written down. It specified the time. Yes, it limited the implied reasonable time, absolutely, but it didn't negate a written term. So under this UCC standard, the court found it consistent enough, provable.
Wow. Okay. So consistency means doesn't directly contradict the words on the page. The UCC really shifts the burden, doesn't it? It's less about protecting the paper and more about acknowledging that parties might not write everything down. Understood. Let's move to the second element then. The court had to find that the writing was not a complete and exclusive statement. How do they justify that?
Right, this gets to integration. Was this little memo intended to be the entire agreement, the final word on everything? The court looked at the fact that the return time was missing, and they reasoned, look, the time for return in a sale on approval deal, that's pretty important. It's a material term. In the court's own words, it was an important part of the arrangement between the parties. Because something that significant was just left out, the court concluded the writing couldn't logically be seen as the complete and exclusive statement of their deal. They also looked at the UCC's official comment, which suggests you should exclude evidence if the term is something that would certainly have been included if agreed upon.
Okay, but wait. If a term is important, wouldn't it certainly have been included? That seems like a contradiction right there. How did the court square that?
They went back to Hunt Food again for the interpretation of certainly. Hunt Food really narrowed that standard down. It said, essentially, that for a court to exclude the evidence based on certainly, the existence of this extra oral term alongside the writing must seem almost impossible. Not just unlikely, not just poor drafting, but virtually impossible to imagine happening. Here, was it impossible that George and Davoli quickly agreed, okay, return by Monday, and just didn't bother adding it to the short sales memo? No, that seemed perfectly plausible, even if maybe not the best practice. Because it wasn't impossible they left it out, the court couldn't say it would certainly have been included. Therefore, the writing wasn't deemed complete and exclusive.
So the UCC approach seems inherently skeptical of finding complete integration unless the document shouts it from the rooftops, maybe with an explicit merger clause, and doesn't have obvious important gaps. And after analyzing both elements, finding the term consistent because it didn't negate anything, and finding the writing not exclusive because an important term was missing, what was the court's final conclusion?
The conclusion was straightforward then. The court admitted the parole evidence, that Monday deadline. Since George, the plaintiff, didn't return the jewelry until Wednesday, he missed the deadline. He breached that part of the agreement. As a result, the court said title to the jewelry had passed to him. Davoli, the seller, was perfectly within his rights to refuse the late return, and George's lawsuit was dismissed. The UCC analysis really flipped what might have happened under the old, stricter common law.
Okay, this is where it gets really interesting. We need to push the boundaries of that Hunt Food rule, that inconsistency requires actual contradiction or negation. It seems incredibly permissive. Let's go back to that hypothetical. We had a written contract for 100 industrial solvents. Delivery. On or about April 1st. We agreed an oral term saying delivery must be by April 5th at the latest is okay, right? It just supplements.
Correct. It narrows the reasonable window implied by on or about, but it doesn't negate the possibility of delivery near April 1st. So, under Hunt Food, it's consistent. It comes in, assuming the writing isn't found complete and exclusive.
Okay, let's twist it. What if the seller tries to introduce a contemporaneous oral agreement stating that delivery will happen not before April 25th? Does delaying the start by over 3 weeks contradict on or about April 1st?
Now that likely crosses the line, yes. The phrase on or about April 1st creates a pretty strong expectation of delivery near that date, maybe a few days, give or take. An oral term pushing the earliest delivery date out by more than 3 weeks. That arguably does negate the core meaning of on or about April 1st. It's not just supplementing, it's fundamentally changing the time frame implied by the writing. That would likely be seen as a direct contradiction and excluded under 2202, even with the low Hunt Food bar. You finally hit negation.
Got it. So narrowing the end date is okay, but drastically shifting the whole time frame, especially the start date, probably counts as contradiction. That distinction really highlights how fine the line can be, but also where the limit is.
And don't forget that first pathway we mentioned, course of dealing, trade usage. If, in our solvent hypothetical, the seller could show that in their past 10 deals with this buyer, a course of dealing, they always delivered big orders 3 weeks after the date mentioned in the paperwork. That evidence would be admissible under 222A to explain what on or about April 1st meant between these parties, even if it seems contradictory on its face, and even if the writing had a merger clause saying it was complete and exclusive. Context evidence like that gets special treatment.
Right. That's a crucial carve-out. So bringing this all together, what does this mean for you, the listener, facing a sales contract problem on an exam or in practice? Can you synthesize these rules, consistency, exclusivity, the context, exception, into a practical step-by-step checklist?
Absolutely. When you see a writing for the sale of goods and someone's trying to bring in outside evidence, run through this 5-step diagnostic. 1, scope check. First things first, is this a contract for the sale of goods? If yes, UCC 2202 is your guide. If no, you're likely back in stricter common law territory. 2, integration level. Is the writing intended as a final expression of at least some terms? Usually, if it looks like a contract and is signed, the answer is yes, at least partially integrated. 3, mandatory context check. UCC 2202A. Is the offered evidence course of performance, course of dealing, or usage of trade? If yes, stop here for this piece of evidence. It's automatically admissible to explain or supplement, period. It doesn't matter if it contradicts or if the writing seems exclusive. 4, contradiction check, the high bar. Now, if the evidence is a specific oral term, not context, does it directly contradict or negate a term actually written in the document? Remember the Hunt Food standard, it has to negate, not just limit or specify. If yes, it's out. End of story for that term. If no, proceed to step 5. 5, exclusivity check. UCC 2202. Okay, the term is consistent. Now, was the document intended as a complete and exclusive statement of all terms? Look hard for omissions. Is an important material term missing, like the return time in George v. Davoli? If yes, a court is very likely to say the writing was not complete and exclusive, and therefore the consistent additional term gets admitted. Remember, the certainly have been included test is interpreted very narrowly. It has to be almost impossible for the term to have been left out.
That's a really powerful framework, a fascinating deep dive into how UCC 2202 really reshaped the parole evidence rule for goods.
Yeah.
It prioritizes, the realities of how business gets done over just the strict formality of the 4 corners of the page.
Yeah.
It creates this significant space for oral agreements to actually matter, to supplement the writing, as long as they don't flat out negate what's on the paper.
Exactly. And the critical thinking point here, the takeaway from George v. Davoli, is crystal clear. If you're drafting a sales contract and you want that writing to be the absolute final word, the only agreement, you have to be meticulous. You need an explicit integration or merger clause saying, this is the complete and exclusive agreement. And just as importantly, you need to make sure there are no glaring holes, no missing major terms. Because if you leave an important term out, like Davoli did, the UCC basically says that door is open for consistent parole evidence to walk right in.
Which brings us to a final thought, doesn't it? Given how low the UCC sets the bar for inconsistency, and how willing it seems to find that writings aren't fully exclusive if important terms are missing, is the parole evidence rule, at least for the sale of goods, less about preventing outright fraud anymore? Is it maybe more about just enforcing intentional, careful, explicit integration? Almost like a penalty for sloppy drafting, something for you to mull over next time you're looking at a sales contract.